A facilities use agreement is a contract between the church and an outside party that extends a license to that outside party for the non-exclusive use of the church's property. This licensee has no right outside the facilities use agreement to use the property. Now, a facilities use agreement helps shield a church from potential liability for injuries that occur on the property and protect the church from unwanted activities on the property. Therefore, it is important that the facilities use agreement contain well-drafted clauses setting forth the terms for how a licensee will use church premises, specifically that the licensee will utilize the property in accordance with the facilities use policy, which should be attached to the agreement. The facilities use agreement should contain language requiring the licensee to carry sufficient insurance and specify what type of insurance is required and the limits of coverage, and if necessary, name the church on the licensee's policies as additional insureds. The agreement should also contain language obligating the licensee to hold the church harmless and indemnify it against any and all claims, which means that the licensee agrees to pay the church back if the church has to pay any kind of damages because of an incident. In summary, a facilities use agreement grants a licensee permission to use the property for a specified purpose within the scope of the church's facilities use agreement and subject to provisions that reduce the church's risk and liability.